Good morning, everyone, and thank you for joining us today at another HR Insight session. For those of you who don't know me, my name is Eugene Wojciechowski, and I'm a partner in our employment team, and you'll also be hearing from Senior Associate Sophie Whitbread and Associate Sophie Humphrey today, who are also members within our employment team. We'll be providing you with an update on the current changes by the Labour government outlined in the new Employment Rights Act 2025. And after we've spoken, we'll have a Q&A session, and please type in online any questions you have in the questions section. Next slide, please. So we've all heard lots of noise about employment law changes over the last couple of years, and this has been referred to as the biggest shake-up in employment law for a generation. Since the proposed changes were first published in the bill in October 2024, there have been approximately 600 changes, so it hasn't been smooth sailing at all for the government. After some last-minute ping-pong, the bill finally was passed on the 18th of December, but there are still a number of ongoing consultations and more will follow. Some changes will come into effect on the 18th of February, but we should see the main changes in April this year. Next slide, please. Today, we're going to focus on what we believe the key points to be in respect of changes, when they're likely to be implemented, taking into account the government's roadmap published on the 1st of July. And we'll also be providing some practical tips on dealing with the changes and how best to prepare now for such changes. Next slide, please. First of all, I'm going to be looking at the changes to come into effect regarding unfair dismissal rights. Currently, in most cases, employees have to have continuous service of at least 2 years before they can raise an employment tribunal claim for unfair dismissal. The Labour government originally proposed to bring in day one unfair dismissal rights at the beginning of employment, but the House of Lords pushed for amendment and a qualifying period of 6 months continuous employment was later substituted. In respect of unfair dismissal claims, unfair dismissal is normally limited to 52 weeks gross pay or a statutory cap currently at £118,223, whichever is lower. You'll know that this is a very different situation for discrimination and whistleblowing claims where damages are uncapped. And under new legislation for unfair dismissal, both the 52-week and financial cap are to be abolished. There's also a basic award provided in addition to such compensatory award for unfair dismissal claims, which is calculated in the same way as statutory redundancy pay, but this will not be changed. It's expected that the reduction in the maximum length of continuous service to bring an unfair dismissal claim, sorry, minimum length, is to be 6 months coming in from the 1st of January 2027. And it's assumed that this will also be the case for the removal of the statutory cap on compensation, but this isn't totally clear at the moment. With the risk of more employees having the right to raise unfair dismissal claims, which may be more costly due to the removal of the statutory cap, employers should be considering, first of all, changing probationary periods to periods of at the very most 6 months and probably less to enable you to manage the situation before employees have 6 months service, and also for employee performance and conduct to be particularly focused on during the probation periods with regular review meetings. Performance management processes will be critical during the first 6 months of employment and should be reviewed to ensure employees' performance has been sufficiently considered during the first 6 months of employment. Managers should also be trained to ensure they are competent at managing performance and misconduct due to the risk of more expensive claims. And they should also be made aware of the requirement to deal with issues early on at the start of employment, including performance management. Also, where there's employees with less than 2 years service, where it's likely not to be working going forward, there is the option of termination before the 1st of January 2027. And this may also be the preference for high paid individuals with over 2 years service due to uncapped compensation coming in. Next slide, please. Currently, the UK has limited state enforcement of employment rights, and the new Act will give the government various powers of employment related regulation and will delegate this to a new public body, which is expected to be called the Fair Work Agency. The Fair Work Agency is proposed to bring together existing enforcement functions, including those that relate to national minimum wage, statutory sick pay, and employment tribunal penalty schemes, the labour exploitation and modern slavery, employment agency rules, and the introduction of the state enforcement of holiday pay. Proposed enforcement powers include the ability to go into premises to look for documents and records, including those on computer systems and other electronic devices. Where insufficient holiday pay or statutory sick pay has been paid, a notice to make the payments may be provided by the Fair Work Agency with penalties of 200% of the sum due for non-compliance. And the Fair Work Agency will also be able to cover its own enforcement costs. The Fair Work Agency will also be able to bring claims on behalf of employees and provide legal assistance. The Fair Work Agency is due to be established in April 2026, but it's likely to take some time to get it up fully running. And obviously some teething issues will be in place initially, which will need to be sorted out moving forward. Employers are advised to undertake audits to ensure there's a full national minimum wage, statutory sick pay, and holiday pay requirement compliance. And there are systems and processes also in place going forward with adequate records to demonstrate compliance. There will also be an increase in the limitation period for employees to raise certain claims to 6 months, where there's a current 3-month limitation in place, including claims for unfair dismissal. The change is proposed to take place in October this year, and with longer periods, it may be more important for employers to keep adequate records to ensure they can deal with claims where memories may not have faded. Next slide, please. The Trade Union Act 2016 imposed various limitations on strikes, including longer notice periods, restrictions on picketing, higher ballot thresholds for certain important public sector services, and the expiry of industrial action mandates after 6 months. Also, industrial action balloting must be done in secret by post. The new legislation repeals the Strikes Minimum Service Levels Act 2023 and most of the Trade Union Act 2016, effectively removing most of the restrictions on calling strike action introduced by the Conservative-led government since 2010. The new legislation also simplifies the information which unions must provide to employers in notices of ballots and industrial action, lengthens industrial action mandates to 12 months, reduces the notice required for industrial action from 14 to 10 days, and allows for electronic balloting. The relevant changes mentioned will be introduced on the 18th of February this year without further consultation. Also, a simplification of the trade union recognition process and the introduction of electronic balloting is expected to be introduced in April 2026. New slide, please. There is currently no general right for trade unions to access workplaces for recruitment and organisation of members. Under the new law, trade union officials will have a right to access workplaces for recruitment, organising, not including organisation of industrial action, and collective bargaining purposes, subject to following a prescriptive statutory process. This includes digital virtual access, which will potentially help unions to engage with workers more effectively. The new legislation will also strengthen protection for trade union representatives and provide increased protection against detriment for taking industrial action, with new protection for employees against detriment short of dismissal for taking part in protected industrial action. Employers will also be required to inform employees of their right to join a trade union in their written statement of employment particulars, and this will be expected to be regularly communicated to employees. Such changes are expected to take place in October 2026. And you should note that our next HR Insight session will focus on changes to trade union and industrial relations legislation. And I'll provide you with further details of this later on in today's session. Non-unionized employers should now be thinking of creating employee forums or engaging more with existing ones to avoid employees seeking trade union recognition. Also, where recognition is being pushed by employers, employers may wish to consider recognizing a trade union they choose rather than having one they don't want to work with pushed on them through statutory recognition. It would also be sensible to consider amending employment contracts and written statements of employment, particularly shortly before October, to include provisions notifying employees of the right to join a trade union. I'll now hand over to Sophie.
Thanks, Eugene. I've got some details of some changes to the harassment at work legislation. First of all, a reminder that the Equality Act was amended in October 2024 to require employers to take reasonable steps to prevent the sexual harassment of employees. And the consequence of that, as you probably know, is that there could be an uplift in compensation where there's a successful tribunal claim in relation to discrimination by up to 25%. The Employment Rights Act amends this to require all reasonable steps to be taken. So that obviously increases the level of responsibility for the employer. And that's due to come into force in October of this year. The Employment Rights Act will also introduce the duty to take all reasonable steps to prevent third-party harassment. That's not just in relation to sexual harassment, but in relation to any protected characteristic. So that might be, for example, age, race, or disability. And a third party here is someone other than the employer or one of their employees. So that includes directors, trustees, contractors, agency workers, visitors, clients, and customers. So the range there is pretty broad. That will also be enforced in October 2026. We are expecting regulations to specify the steps that are regarded as reasonable, but that's not likely to be enforced until 2027. So there's going to be a bit of a gap there. Also, in relation to sexual harassment, whistleblowing protection will be strengthened by making it clear that a report of sexual harassment amounts to a protected disclosure, which, as you know, then gives employees and workers protection from dismissal and detriment. Arguably, that is already covered by the existing legislation, so it's questionable whether it legally makes any difference. But there's a clear statement of policy there that that's something that's important enough to amount to a blowing of the whistle. That change comes into force in April 2026. And a final change in relation to harassment is in relation to non-disclosure agreements. So this will be the case that any provision in an agreement that prevents the disclosure of harassment or discrimination will be void. So that's going to have a big impact on settlement agreements. Those clauses in relation to confidentiality and the making of derogatory statements that are typically included in settlement agreements are going to need to take this into account. We do expect there to be some narrow exceptions to this, and the government is going to be consulting on what those could be. We may find a situation like we have in Northern Ireland at the moment, where NDAs are allowed if they've been requested by the employee and the employee has had legal advice which has been paid for by the employer on the NDA. But I think whatever happens, those exceptions are going to be quite narrow, so employers do need to be ready for this change. Not quite sure when this is coming into place. As I say, there's going to be consultation first. In terms of what to do now in respect of these upcoming changes, we've all known that the change regarding the duty to prevent sexual harassment was going to be increased to the requirement for all reasonable steps since October 2024. So we've been advising our clients from the very beginning to have that as their aim. Now is a good time to be looking back to risk assessments that you did at the time, any policies that you've put in place, any training that you've put in place. Have a look at how well that's going, what's working well, what might need changing in preparation for this October. It's worth having a look at the EHRC's technical guidance on sexual harassment and harassment at work, as that includes some examples on the reasonable steps that you might need to take. And that's particularly helpful, I think, as we wait for the regulations coming in to provide details of what does amount to all reasonable steps. Particularly if you are a service provider and you've got lots of customers or clients coming in, but even in any other industry where you might have anybody coming in who's a third party, do have a look at your third party arrangements. What might you need to do to prevent harassment in the workplace from third parties? That might be signage in public places, clauses in contracts, training for those working on site, and policies. Do update your whistleblowing policies by this April to make sure that you're noting that sexual harassment reporting does constitute a blowing of the whistle as well. And watch this space regarding non-disclosure agreements. Be ready to amend your agreements and do contribute to any consultation as it comes along. On to the next slide, please. There are then going to be some updates on the flexible working regime. Currently, an employer can refuse a flexible working application on one of 8 statutory grounds, which I'm sure you're familiar with. They include, for example, the burden of additional costs or the inability to recruit additional staff to cover the work. Under the new proposals, an employer will still be able to refuse an application on the same 8 grounds, but must also be able to show that it is reasonable for them to do so. So that introduces an element of objectivity which has to be evidenced. The employer will also have to follow a specified consultation process, and we're waiting for details of what that will be, and be able to explain to the employee why their decision was reasonable in their view. We expect a consultation on that early this year, with the changes in law coming into force in 2027. So in terms of what to do now, it's good practice anyway to ensure a decision on a flexible working request is properly reasoned and explained to the employee. So it's a good time to strengthen your policies and your manager training to make sure that decisions are carefully thought through and recorded as such as a matter of course, and then you'll be well prepared for the changes next year. Do look out for the consultation and contribute as you want to. On to the next slide, please. We then have some changes to family-friendly rights. So currently paternity leave has a 26-week qualifying period, and in order to take unpaid parental leave, an employee needs to have been employed for 1 year. Those will both become day 1 rights as of this April. The requirement for paternity leave to be taken before shared parental leave will also be removed as of April. There'll then be a change so that it is automatically unfair to dismiss a pregnant employee or new mother until she's back at work for at least 6 months, save in specified circumstances. There's a consultation underway in relation to what those circumstances should be, which closes today, and that's looking to be in force in 2027. Also in 2027, the Act will introduce a statutory right to at least 1 week of unpaid bereavement leave as a day 1 right if it concerns the death of a close relative. Bereavement leave will include employees also who experience pregnancy loss before 24 weeks, which isn't currently covered by the legislation. Again, the consultation started in October and closes today, and that's looking at the types of relationships that will be eligible for the leave, the timing of the leave, and the notice and the evidence requirements. So do review your family leave policies now regarding the paternity and parental leave changes ready for April. Keep an eye out for future changes, and do, if you can today, contribute to those consultations, which are still just about open. On to the next slide, please. And finally, for me, a word on equality reporting. So large employers, which is those with more than 250 employees, are going to have to produce gender equality action plans, which will sit alongside your gender pay gap reporting. Those action plans need to address what's being done about the gender pay gap and how employers support employees going through menopause. It will also need to include information in relation to reducing the risk and prevalence of sexual harassment in the workplace. Those reports are going to be compulsory from 2027, although they can be done voluntarily from April this year. We're also looking at ethnicity and disability pay gap reporting, potentially from 2027, again for larger employers. So I think it's worth starting to gather your data now. It's never too soon. Think about action plans. Some of you may well be doing that anyway, so that you're fully ready in the various areas on which you'll need to report. I'll hand over now to Sophie, who's going to talk about fire and rehire and a number of other topics.
Thanks, Sophie. Good morning, everyone. So starting with fire and rehire today, or dismissal and re-engagement as it's often referred to, these new proposals are going to be implemented from October 2026. There's been a lot of back and forth about this, but under the more recently amended provisions, it is going to be deemed to be automatically unfair to dismiss someone when they refuse to agree to a variation of their terms and conditions of employment when the proposed variation is what's termed as a restricted variation. So the current understanding is that a restricted variation is going to include reductions to pay, changes to measures of work done where these determine an element of pay, so for example, sales commissions or target hours, changes to pensions, changes to total hours worked, reductions to leave entitlements, and specified changes to shift patterns. Additionally, if an employer seeks to impose a clause in an employment contract that seeks to vary any of these elements in itself, that clause in itself will be a restricted variation. So essentially, you can't circumvent any of these restrictive variations with a clause in the contract. On the flip side, automatic unfair dismissal will not be triggered where changes are considered routine and non-detrimental. That's not been defined, or in circumstances where the changes relate to a place of work. However, it would be wrong of us not to flag that it doesn't mean that routine and non-detrimental variations can be made without the risk of an employee bringing a claim. And if a tribunal is going to consider the fairness of any dismissal for refusing to agree a variation that's not a restricted variation, they'll take into account a number of factors. And I imagine they'll essentially be applying the same reasonableness test that they'd apply to an ordinary unfair dismissal claim. So it's worth being mindful of this. The Employment Rights Act is also going to make it automatically unfair to dismiss an employee where they're replaced by an individual who is not an employee of the employer, and that person will undertake the same or substantially the same activities as the employee performed prior to dismissal. So that is also something to bear in mind. Dismissal and re-engagement will still be possible in very limited circumstances where it could not be reasonably be avoided. And the changes in response to financial difficulties that would likely affect the ability of the business to continue. This is going to be called the financial difficulties exemption. Of course, if that's going to be applied, the advice would be that employers are going to need substantial evidence to support the application of that exemption. In terms of action points here, we're recommending that employers are starting to look at their existing contracts to understand what flexibility provisions are currently in place and to what extent they can be utilised in future without triggering that restricted variation provision. They should also be considering whether any future proposals to change existing terms and conditions should be brought forward prior to those changes coming into force. And there's also that shift in restrictions on replacing existing staff with agency workers. So if this is something that a company tends to do, then that's something worth looking at doing it sooner rather than later prior to the changes coming into onto the next slide, please. So I'm going to be looking at the changes for collective consultation next. The current threshold for collective consultation is that when an employer proposes 20 or more redundancies at one establishment within a 90-day period, they must go through the collective consultation process. And if they don't comply, they're liable to pay a protective award of up to 90 days pay per employee, and that is not capped, so it's quite a substantial sum anyway. The first change that is going to come into effect is that maximum penalty is going to be increased. So if there is a breach to the collective redundancy consultation requirements, that 90 days is going to increase to 180 days. It's going to double. That will be per affected employee. So that's a significant punitive increase. That change is going to come into effect from April 2026. The second change is in relation to triggers. So it was originally proposed that the requirement for redundancies to take place at one establishment would be removed. Meaning that redundancies across a business would be taken into account when considering whether a collective consultation would be triggered. Understandably, this was really unpopular with employers, so the proposals were amended in March 2025, and now there will be a new alternative threshold where redundancies are made. We don't know what that threshold is yet. The Secretary of State is going to have the power to set it. It could, for example, be a percentage of the workforce that triggers that duty, but it's anticipated that this element is not going to come into effect until 2027. So I don't suppose we'll find out for a while yet, but it's something to keep in mind. In terms of action points, obviously we'd recommend reviewing existing redundancy policies and making sure there's awareness across the organisation, because you're going to need processes in place to track redundancies and any changes to terms and conditions, not just on a site-specific basis, but also across the business to make sure you're not falling foul of any obligations. And also, if you're considering reorganisation, we'd recommend doing so earlier rather than later. On to the next slide, please. The next change is in relation to 0-hour contracts and irregular workers. These changes are going to come into effect in 2027. The first is in relation to guaranteed hours. So there's a lot of definitions, and there's actually a lot of elements in relation to the 0-hour contracts that are not yet defined, and we're waiting for further consultation. The Employment Rights Act 2025 has defined a 0 hours contract as a contract of employment under which there is no certainty that any work will be made available to the worker. A low hours contract isn't yet defined. We understand it will be defined in future regulations following consultation. But under the new Act, a qualifying worker means both a 0 hour worker and a low hours worker. And employers must offer qualifying workers a guaranteed hours contract after an initial reference period and after every subsequent reference period. This means that the number of guaranteed hours will have to reflect the average hours that were worked by that individual during a defined reference period. Again, we don't know what the reference period will be, but it's expected to be a period of about 12 weeks. So what this means is at the end of each reference period, employers are going to be required to offer a qualifying worker a contract that guarantees them the hours that reflects the actual hours that they worked in that reference period until they're no longer classed as a qualifying worker. So again, if their working hours then change and they work more in the next reference period, it's going to have to be continuously assessed. And employers are required to either offer to vary the worker's existing terms to guarantee the hours worked or to issue a new contract. There's also going to be the obligation for reasonable notice of shifts as well, and that relates to shifts, shift cancellations, or shift changes. Specified period for notice, we anticipate it's not going to exceed 7 days, but again, that's yet to be confirmed. And the government has confirmed that those provisions are going to extend to agency workers as well. Compensation is going to be applied for cancelled or changed shifts too. Again, lots of this is still subject to consultation and future regulations, so keep an eye out for those. And it will be possible for workers to bring claims for unfair dismissal and detriment at the employment tribunal if an employer fails to comply with the duty. The tribunal is going to have the power to award just and equitable compensation in relation to failing to provide that guaranteed hours contract. The compensation is going to be subject to a cap, which again hasn't been set. And it's going to be deemed to be automatically unfair to dismiss an employee if the principal reason for dismissing them relates to rights concerning guaranteed hour offers. So in terms of action points, it's worth reviewing and updating contracts now, implementing a process for monitoring reference periods, so ensuring you've got the technology to do so and making sure this is also consistent across the business. And this is definitely also going to require training for managers as well. They're going to need to be informed of how to track the hours worked, but also what the implications are if shift changes are made last minute, shifts are pulled and that kind of thing. That's going to be quite a large change. So it's worth bearing in mind. On to the next slide, please. And then finally, looking at holiday and sick pay. So looking at statutory sick pay first, that current 3-day waiting period for statutory sick pay to kick in is going to be removed. So that's going to be available from day one of sickness absence from April 2026. The earnings threshold is also going to be removed. So statutory sick pay is going to be available to all workers regardless of their earnings. And the same rate is going to apply to all workers aged 18 or above. And in relation to holidays, employers are going to be required to keep records showing compliance with the rules on statutory holiday entitlement and pay for at least 6 years, and failure to do so is going to be a criminal offence. So that's really key as well. The action points there are going to be to review policies in relation to eligibility thresholds and waiting days for sick pay, and to, of course, review retention policies and make sure you are keeping the information on holiday pay as well. And that is everything from me this morning.
Thank you, Sophie. Well, as you can see, we've had a lot of information to cover, and we've got very limited time to deal with any questions which you've raised, but we'll try and deal with one or two. We've only got a couple of minutes left for today's session. The first question we have is, we have a 9-month probation period with the option to pass early for exceptional performance, carrot rather than stick. And this has worked very well for us and as a thorough and supportive process. Ideally, we want to keep this in place. Can we keep this in place, but with a more thorough process, should we decide to end employment where there's over 6 months? You could certainly keep it in place, but I like the idea of you being in a situation where you feel your process is working very well when it comes to monitoring performance during probation. But the difficulty you've got is, as soon as employees have 6 months continuous service, they will be entitled to raise unfair dismissal claims. So I would generally advise to reduce probation periods to end perhaps at around the 5-month period, because I feel often with businesses, probation periods finish and then they're looked at and there are delays, and you need enough time if you decide to terminate before somebody's deemed to have 6 months service. And you'll remember that employees will still be entitled to 1 week's notice, which could potentially take them over the 6 months. And also, if you're paying them in lieu, you may have the statutory period added on to that, the 1 week statutory period, when you're assessing continuity of employment. So I'd really be trying to push for things to be dealt with by month number 5, and certainly having everything dealt with and making a decision well before the 6-month period in which an employee obtains continuous service and can claim unfair dismissal. The second question we have, and this is perhaps something for Sophie to deal with. It says the bereavement leave, including miscarriage, under 24 weeks. Is this eligible for only a couple of days? And what, if any, evidence of the pregnancy is needed? I think this is one for you, Sophie.
Thank you. Yes, I think it is going to be eligible right from the beginning. In terms of evidence, that's one of the things that the consultation is looking at the moment. So if you've got views on that, do contribute. I think the tenor of the consultation paper is very much that employers ought to be sensitive around bereavement and not asking for a huge amount of documentation. That's certainly the way that it currently works, but they are asking for views on what kind of evidence is required in respect of the different types of bereavement leave. So whether that's pregnancy loss or the other kinds of leave. So I think the answer to your question is we don't know just yet about evidence, but do contribute. But I suspect we will head towards little evidence or no evidence as opposed to having a very high evidence requirement.
Okay, unfortunately, there were some further questions, but time has run out. We've gone slightly over by a couple of minutes. But thank you all very much for attending. And as you can see, it's going to be a very busy year for HR and anyone practicing within the fields of employment law. And we're going to be hosting a number of other HR Insight events, and we look forward to seeing you at the next one. The next one will be taking place on Thursday, the 12th of February, and it's going to be focusing on trade union and collective rights under the Employment Rights Act. You should receive an invitation for this shortly, but I put this in your diaries. It's going to be at the same time on Thursday, the 12th of February. And we also have further HR Insight session booked to take place on the 19th of March. And this covers the Employment Rights Act essentials, increased unfair dismissal rights and beyond. So again, we're going to be very much focusing on the employment right changes over the next few months. And you should also keep an eye on the Employment Rights Hub on our website, which will provide regular updates in connection with the changes. Thank you very much for attending today, and I look forward to seeing you in the near future.